The police arrest a man. He confesses. And then it comes out. They never read him his rights. On TV, this is the moment the case falls apart. The detective slumps. The suspect walks free. Case dismissed. Except that's not what happens. In real life, that confession can get thrown out, and the man can still be convicted anyway. If he told them where the gun was, they keep the gun. It still counts. So here's what actually happens when police don't read you your rights, because almost everything you think you know about it is wrong. You know the words by heart, even if you've never been arrested. You have the right to remain silent. Anything you say can be used against you. You have the right to an attorney. We've heard it in 1,000 movies and crime shows. And from all that TV, most people walked away with one big belief. If the cops skip those words, the whole case is dead. That single belief is the myth this whole video's about. Because the warning is real, but what it actually does is much smaller and much stranger than the screen ever told you. It starts with a 1966 Supreme Court case, Miranda versus Arizona. The court's worry was simple. Lock someone in a police interrogation room alone for hours, and the pressure to talk can become overwhelming, enough that a confession isn't truly a free choice. So the court required a set of warnings first to protect a right that was already in the Constitution. The Fifth Amendment, a right not to be forced to incriminate yourself. The warning didn't create a new right. It's a heads up about a right you already had. But here's the catch almost nobody knows, and it's the key to the entire myth. Police don't have to read you your rights every time they talk to you. Not on the street, not during a traffic stop, not even always after they've arrested you. The warning is only required in one specific situation, and if that situation isn't happening, they can skip it completely, and nothing they hear is thrown out. That situation has two ingredients, and you need both. The first is custody. And custody is narrower than people think. A cop walking up and asking questions, not custody. A routine traffic stop where you're expecting a ticket and then to drive off. The Supreme Court has said that, by itself, is not custody either. Think of it as a line. On one side, you're free to end the conversation and walk away. Cross to the other side, handcuffs, a locked room, a reasonable person who'd never feel free to go, and now you're in custody. The second ingredient is interrogation, and it's broader than just barking questions. If officers do something they should know is likely to make you blurt out something incriminating, a staged conversation meant for your ears that can count as interrogation too. But you need both ingredients at once, custody without questioning or questioning without custody, and the warning isn't required. Only when the two overlap, you're locked down and being questioned, do they finally have to read you your rights. So look at all the moments that fall outside that overlap. Getting booked, fingerprinted, photographed, no warning needed. Chatting with an officer before any arrest, no warning needed. And this is the big one. Anything you volunteer, unprompted, that nobody asked you, that always comes in. Blurt out a confession in the back of the squad car while the officer says nothing, and it counts, warning or no warning. The warning guards one narrow doorway. Step around it, and everything you say is fair game. Okay, so say police get it wrong. They question you, in custody, with no warning, and you talk. What's the actual consequence? Not dismissal. The remedy is something much smaller called suppression. Here's the way to picture it. The warning isn't a key to the whole building. It's a key to one room, the interrogation room. Break the rule, and the judge locks that one room. The statement you made in there can't be used. Every other room in the case, the evidence, the witnesses, the arrest, stays wide open. So walk it through. Police question you in custody, skip the warning, and you say something incriminating. Your lawyer files a motion to suppress. The judge agrees, and that statement is kept out of the prosecution's main case. And then the case keeps going. On the physical evidence, on the witnesses, on the surveillance video, on everything the police already had or find later on their own. If the confession was the only thing they had, losing it can gut the case. But that's just weak evidence, not a rule that says the charges must be dropped. No warning does not mean no case. And now the fact that breaks the myth completely. Imagine a suspect in custody, no warning given, who blurts out, "The gun's under my mattress," Police go look, and there it is. That sentence, "The gun's under my mattress," gets thrown out. But the gun. In 2004, a divided Supreme Court said the gun comes in. The physical evidence the words led them to is not suppressed. The murder weapon, the stash, the body, police keep it. The confession gets tossed. The gun still counts. That one rule has ended more cases in the prosecution's favor than any warning ever saved. There's one more twist that makes that locked room even leakier. Say your unworn statement is suppressed, kept out of the prosecution's main case. Good. But then you take the witness stand at trial and say something different. The Supreme Court has said that suppressed statement can come back out, not to prove you're guilty, but to catch you in the lie. The key that only locked one door still swings open a side door if you contradict yourself on the stand. Miranda is a shield against the state's case. It is not a license to say the opposite under oath. Now flip it around. If the warning is so narrow, how do you actually protect yourself? And here's where people get the biggest shock of all. The right to remain silent does not turn on by itself. You have to invoke it. Think of it like a light switch. Everyone assumes it's already on, that the moment you stop talking, you're protected. It isn't. Sitting there silent, saying nothing, leaves the switch off, as far as the law is concerned. In one case, a man stayed nearly silent through almost 3 hours of questioning, then said a few incriminating words at the end. The court ruled he'd never flipped the switch. Silence alone didn't count as invoking it. The same trap catches people with the right to a lawyer. You'd think mumbling something about an attorney would stop everything. It doesn't. In a case decided narrowly, the Supreme Court held that asking for a lawyer has to be clear and unambiguous. A suspect who said, "Maybe I should talk to a lawyer," the court said that wasn't a real request. Police didn't even have to stop and ask what he meant. They kept going. Asking for a lawyer is a magic word, not a mood. "Maybe I should get a lawyer's thinking out loud. I want a lawyer's the one that actually stops the clock." It gets sharper. Your silence can even be used against you before you're arrested, before any warning at all. In one case, a man was answering an officer's questions voluntarily, not under arrest. Then came a question about whether shell casings would match his shotgun. He went quiet. And at trial, prosecutors pointed to that silence as a sign of guilt. A divided Supreme Court allowed it. Because he was not in custody and had never expressly claimed his right, his silence wasn't protected. The lesson is blunt. Outside the interrogation room, staying quiet isn't automatically a shield. You generally have to say you're using the right. But once you do invoke, clearly the rules flip hard in your favor. The moment you say you want a lawyer, questioning is supposed to stop. The court agreed on this one. After you ask for counsel, police can't just keep working on you until they get a better answer. They have to wait for the lawyer, unless you restart the conversation yourself. So the clear words don't just help a little. They slam the interrogation room door shut. Except that SHIELD has a battery, and it can run down. The Supreme Court later said the protection from being reapproached lasts while you're in custody. But if you're released and go back to your normal life for 14 days, it resets. After that break, police can come back, read you the warnings again, and try once more. Picture the SHIELD running on a battery that only drains when you're out of the cage. Stay in custody, and it holds. Go home for 2 weeks, and it quietly dies. And there's a wrinkle people constantly mix up. Invoking silence and invoking a lawyer are two different tracks. Ask for a lawyer, and you get that hard door slam. But if you only say you don't want to talk right now, police can, in some cases, come back later, as long as they truly honor your choice. They stop when you say, "Stop," let real time pass, and read the warnings fresh before trying again. Same booth, two different rules. The lawyer request is the stronger lock. So if you strip all of this down to what actually matters, and this is general legal education, not advice for your specific situation, it comes to one thing. Ambiguity works against you. Silence can be read as a waiver. A hedge about a lawyer can be treated as nothing. The one move the law can't twist is a clear, explicit statement, something like, "I am invoking my right to remain silent, and I want a lawyer." That leaves no room for a reasonable officer to pretend he wasn't sure what you meant. Now, even the narrow warning has exceptions, moments police can skip it and still use what you say. The biggest is public safety. In one case, officers chased an armed suspect into a supermarket, cuffed him, found an empty holster, and, before any warning, asked, "Where's the gun?" He told them. The court let it in. Think of it as a fire alarm. When there's an immediate danger, a loaded gun loose in a public store, the law lets police pull the alarm first and read the safety pamphlet later. Police also tried a clever trick, and the court had to shut it down. The trick? Question a suspect with no warning until they confess, then read them their rights and have them repeat it. Warn second, so the first confession greases the second. When officers deliberately did that, the court threw out the repeat. But an honest mistake is treated differently. If police simply slipped up once without any strategy, a later, properly warned statement can still be used. The line the court drew is between an accident and a deliberate end run around the rules. By now you might be thinking, if these warnings are such a technicality, why not just get rid of them? Someone tried. Congress. Back in 1968, Congress passed a law meant to cancel Miranda, to say a confession just had to be voluntary, warnings or not. And then, something strange happened. That law mostly sat there, unused for over 30 years. In 2000, it finally reached the Supreme Court in a case called Dickerson, and the court, by 7-2, written by a conservative Chief Justice, struck the law down. Miranda, it held, is grounded in the Constitution itself. Congress can't simply legislate it away. The warnings are a constitutional floor. So the warning is constitutional bedrock, which brings us to the most surprising turn of all, and it's recent. Say police violate the rule, skip the warning, question you in custody, use your words. You'd assume you could sue them for it. In 2022, the Supreme Court said, generally, no. In a case called Vega versus Teco, decided 6-3, the court held that a bare Miranda violation, just failing to warn, is not by itself something you can sue an officer over for money damages. The court described the warnings as a preventive safeguard built around the Fifth Amendment right rather than the constitutional right itself. And because the lawsuit needs a violation of a constitutional right, skipping the warning alone didn't qualify. Now be careful, because this is easy to overstate. Vega did not make unwarned confessions suddenly usable. Suppression still works exactly as before. The statement still gets thrown out at trial. That never changed. What changed is the after-the-fact lawsuit. If police fail to warn you, you generally can't turn around and sue them for damages just for that failure. The remedy stays what it always was, keeping the statement out of court, not a check. And this is where fair-minded people genuinely disagree, so we're not here to pick a side. Both sides are looking at the same question. What actually keeps police honest, throwing out the evidence or the threat of being sued? There's a crucial line to hold on to here, though. Skipping the warning is one thing. Actually forcing a confession, real coercion, threats, breaking someone down, is a completely different and far more serious violation. Vega did not touch that. In fact, in the very same case, once it went back down, the courts allowed the separate claim about a coerced confession to move forward. Forgetting the warning and beating a confession out of someone are not the same, and the law still treats them worlds apart. And if this all sounds abstract, it isn't. It plays out in real courtrooms right now. Just weeks ago, in 2026, a state Supreme Court threw out a man's confession. Police had told him, after he asked for a lawyer, that he couldn't have one. Another officer even reread him the warnings in full a bit later, but the court ruled the earlier deception had already broken the rules and suppressed what he said. It's a live, modern echo of that same door slam principle. Once you clearly ask for a lawyer, police can't talk you out of it. The warning is old. The fight over it is very current. Step back, and you can see the whole arc. 60 years of the court doing two things at once, keeping the warning alive as a constitutional rule, while narrowing again and again exactly what happens when it's broken. So put the myth to rest. If police don't read you your rights, here's the real picture. Your case is not automatically dismissed. You do not walk free. At most, one thing you said in custody gets kept out of the prosecution's main case, and even then, the physical evidence it led to usually stays in. The warning isn't a magic spell that voids everything. It's a narrow rule with a narrow remedy, full of exceptions. Which leaves the real question the country keeps arguing over. The warning protects you against the pressure of a locked room, but the court has steadily shrunk what happens when police ignore it. No dismissal, physical evidence preserved, and now, usually, no lawsuit. Supporters say that's the right balance. Suppress the statement, don't let a technicality free the guilty. Critics say a right with no real consequence for breaking it starts to feel optional. Where that line belongs, that part, you get to decide. So, what happens if police don't read you your rights? Not what the movies taught you. The case survives. The evidence survives. One statement might not, and you have to speak up clearly to protect even that. It's one of the most famous rights in America and one of the most misunderstood. Now you know what it actually does. Now you know.